Hi, this is Dr. Chris Rapoff once again, and today we're going to take up a subject that not many QMEs have had to deal with, but those of you who have could understand where we're coming from. It's called the sub-Rosa surveillance. So let's get started. First, let's get a correct definition. Sub-Rosa derives from an old Latin term meaning under the rose. And in ancient times and in ancient mythology, the rose pretty much was associated with secrecy. So the term actually defines itself, under the rose or in secret. So now let's see how this applies to us as QMEs and how we may encounter sub-Rosa surveillance. But first I thought we would understand how this could impact us as QMEs and as physicians ourselves with a possible scenario. Okay, now let's take a look at how this may be impacted by a physician or a QME in their reporting. First, let's imagine we have a doctor, as you see here on the screen, testifying on behalf of a patient in a very high-profile personal injury case. In this case, he was a conductor of a train in the lead car, and that lead car was impacted or hit by a UPS truck, and the train derailed. We'll call the train conductor Mr. Smith. And Mr. Smith was otherwise a 42-year-old male that in very good shape with no history or no prior injuries to the cervical spine. In this impact, he suffered multi-level disc injuries to the cervical spine and was rendered unemployable at this job at age 42. Now, railroad employees are protected under an act of Congress called the Federal Employers Liability Act. And this was put in place because it was in recognition of the inherent dangers that are associated with employment on the railroad. So this is a very, very strong case for this gentleman that was impacted by this and hurt. Believe it or not, these cases potentially render seven-figure settlements, and it's not uncommon for that to happen at all. All right, so now this physician is doing everything he can to represent his patient, and he's feeling pretty good about himself as he sits on the stand and explains these inherent issues that are basically now Mr. Smith is dealing with inability to work. So moving right along and go to the cross-examination. This is where it gets interesting. All right, so now you see the physician is feeling pretty good about himself. He's been on the stand and being examined by the prosecuting attorney, and things are going fairly well, looking pretty good for the plaintiff and for his patient, Mr. Smith. And then on cross-examination, they asked to be able to play a video cassette tape for the jury and for the physician to comment on. They placed the tape in, and all of a sudden, there is Mr. Smith, the unemployable multi-level cervical spine injury sufferer, standing at the top of a 20-foot ladder in the second-story gable of his home, painting the top gable of his home. Leaning forward, as you see in these pictures, these are not Mr. Smith, but these are renditions, leaning forward with absolutely looking like he has no issues whatsoever with any type of impairment or disability. This is the product of a sub-Rosa surveillance. Needless to say, there was a lot of egg on a lot of faces in that courtroom, but the defense was feeling pretty good. So moving on to what surveillance of sub-Rosa would be, it's basically a private surveillance that is generally brought on by either party, either the defense or the prosecution, and I'll mention that in a second why. But it's a private surveillance determining that possibly if there is a false claim that could be being brought forward by a plaintiff. These are done in secret. They can be cameras, they can be videotapes, they could be audio tapes. that are done sub rosa. And what you basically are looking at, generally these folks are conducting their normal activities, but we're just seeing what impact their disability and or impairment is providing them or is causing with their activities of daily living. And just to hit more on that, they basically are looking for information. They're digging up information, possibly the daily routines of the individual, maybe hobbies that they're involved in. Are they playing soccer? Are they playing softball? Or are they just walking? Or also, are they working? They may be unemployable in a full-time job, say for instance, as a conductor, but are they picking up part-time jobs somewhere else, and they're seen lifting pieces of wood. They were standing outside Home Depot and looking for part-time work. So these types of issues will come up in a sub rosa surveillance. So of course you think, well, gosh, now that defense is really looking to stick it to the applicant, or in this case to the plaintiff. And so you say, well, the defense, this is always their weapon if they can do that. Well, apparently they're going to try to deny or reduce payouts, and that's their job. However, the plaintiff, also an attorney, can actually ask for sub rosa surveillance on their client themselves. Because isn't it better to know what you're going to be confronted with before you're confronted instead of after? And you can avoid an embarrassment at trial, as you saw in that picture. You may be asking now, how does this affect me as a QME? Well, let's take a look here. Under the California Code of Regulations, Section 9795, which we're all very familiar with, the medical legal fee schedule, there is a payout for a sub rosa review, and it's termed an ML205, and you can charge $325 per hour. So in that case, the physician or the QME is tasked to view sub rosa material and to opine on their findings and or their observations. Once again, a reimbursement of $325 per hour for your time. So you want to keep this in mind, because if you are tasked with reviewing this sub rosa material, although it may seem like a mundane and pretty laborious task for you to provide an hour or two of this type of review, just remember that think of the $325 per hour basically as a reward of sorts. As a QME, you're probably going to see the lion's share of these presentations to you presented by the defense attorney, as they're looking for a reduced payout or a no payout at all. And they seem to maybe have some information that they feel would be of interest to you before you opine on an impairment rating or even a compensability examination, for instance. Now, the applicant attorney, as I had mentioned, should have already done their homework, and there should be no surprises. But if you do see a defense that is asking you to view sub rosa video, they found something. Now, this is not just an audio and a video surveillance. They are also now scouring social media and the media to see if there are any biases or any issues that they can use against an adversary or against the other side. I hope you understand a little bit more now what sub rosa surveillance is and how it may affect us as QMEs, and how you may even be tasked to provide some opinions on some sub rosa surveillance. But I wanted to ask you, do you remember this gentleman here, the clueless doctor that is testifying on behalf of Mr. Smith? That was me. That was several years ago, and that's not a picture of me actually. But I was the doctor that had basically indicated that Mr. Smith was unemployable at 42 years old, and he was no longer going to be employed by the railroad. And needless to say, I had a lot of egg on my face, and I had a lot of recanting my testimony. And as a result, this gentleman, instead of receiving a 7-figure settlement, well, he was reduced to a 5-figure settlement. He did receive some. However, his actions spoke louder than words. So thank you for joining me today, and I hope you enjoyed this and you'll be able to take something away from it in your practice as a QME physician. And until next time, thank you.